today, so they don't need an introduction, but I'm very excited to listen and learn from Brian Panish, Sonia Chopra, and Rahul Ravipudi. Thank you.
Are you coming up here? What are you doing?
I can.
Yeah, so what our program is going to be, we're going to start out by kind of going over some of the basics of our approach to jury selection. As you know from the title, it's jury selection in limited time circumstances. So sometimes you have judges who, regardless of what the law says about time limits, say, okay, here's 18 people, you've got 30 minutes to talk to them. So we're going to talk about sort of our general philosophy, then what do we do in those time-limited situations to maximize. And then in our second hour, we're going to bring some mock jurors in, and Brian's going to demonstrate how we would do a very limited voir dire in a specific case that we actually did. So we've brought in some tools and techniques that we've used in that trial. And then for the last portion, that's when Rahul's taking over. He's going to be the judge for the mock trial, and then he's going to switch it up, and these two are going to show you how to do rebuttal arguments. So they're going to be a bunch of different ones. Rahul's going to throw them out, and Brian is going to turn around and come back. So that's what we'll do in the third hour. All right? All right, and you know, it's a small enough group that I think if you guys have questions as we go through, just go ahead and raise your hand and ask us. We're happy to take questions as we go. All right.
We have a
PowerPoint up. Okay. So again, limited time. How many people here have time limits in your jury selection? I know some places they go forever, right? For many, many days. All right, well, we're talking probably 30 minutes is what we're going to be working with here today. So what do? The first thing that we do is we always want to remember, of course, that it's jury deselection. We're not going in there saying, who do we want? We're going in there saying, who do we not want? What are our areas of concern? And particularly when you have only a limited amount of time, you have to narrow it down to like 3 things that you are most worried about. And that's really where you're going to focus your jury selection. This is not the time to be like, oh, where'd your kid go to school? You know, or what's your bumper stickers? We really have to focus on the primary issues in our case that are going to prevent us from getting the verdict that we want. And I always say this in every session, so if you've seen me before, I apologize, but what are you not, demographics are not what you're basing your decision on, right? The order of importance in terms of how jurors are going to react to your case, the most important is life experiences. Their personal life experiences carry more weight than anything else in terms of how they're going to filter things and how they're going to see the evidence in your case. So first, life experiences that are relevant to your case. Next is general attitudes. Attitudes about damages, particularly, is where we would spin. If we have only one question to ask, we're probably going to ask about non-economic damages, because for us, that is the one that really kind of separates the wheat from the chaff. That's where all of your tort reform jurors pop up, more so than in your standard too many lawsuits question. Really asking about the concept, their thoughts about the concept of awarding money for don't say the word non-economic, say emotional distress, loss of enjoyment of life, mental suffering. Those are the ones that definitely trigger your tort reform jurors. Now, I always say pain, sometimes even tort reform jurors will give money for pain, but they hate to give it for loss of enjoyment of life. So whatever, you know, those trigger words are in the statutes in your jurisdiction, you want to use those. All right. So what do? Again, I kind of jumped into this. We're thinking about what are our 3 to 5 most problematic topics. And so in any given case, it may be the nature of the case itself. A good example is motorcycles. Motorcycle cases are always triggering for people. Pedestrians, bikes, med-mal, you know, what are the attitudes about the particular case? Slip and fall is a big one. People hate slip and falls. So kind of thinking about what are the elements of your case. But then what you also want to be thinking about is what are the 3 things that are keeping you up at night, right? What are the areas where if you're going to lose, this is why you're going to lose? And that's really where you want to focus and structure your questions around. Again, life experiences, then attitudes and beliefs. So demographics, I would say the only time that I ever think about demographics is if it's related to the trial. And what do I mean by that? Like, maybe in an employment case, right? In a discrimination case or in a civil rights case. Then I might be thinking about the demographics of the jurors. But otherwise, it's so variable. Why would a woman be better for your trial? It just doesn't, there's no rhyme or reason to it. So we're all kind of ingrained to think that way. And so so it's something that I have to constantly work with everyone with, all of my clients, and say, no, we're not gonna just make an assumption about this person because of who they are, how they look. So one of the things that's really important, especially when you have limited time, it's easy to say, oh, I'm not gonna look at that guy, he's gonna be great for me, the guy loves me, I'm not even gonna ask him any questions. It's a mistake. You need to make sure that you take the time to ask every single juror at least one question, because often it's the silent ones who are the killers. There's a couple of great articles by a federal court judge, Judge Mize, and it's called, I think, Be Careful of the Quiet Ones. And he had done an experiment where typical federal court judge, he wasn't asking very many questions, he was just asking panel questions. And he decided to do an experiment where he took each juror back into chambers and questioned them individually. And the results will blow your mind. He's like, the number of cause challenges that generated just from having that individual discussion, it was something like 60% of the panel that he would have just let go through when he started asking the actual questions, revealed things that were crazy. Like one of them, the defendant doctor was like, had operated on them. And they're like, well, they didn't really ask me that question, right? So it just goes to show you really need to make sure that you ask everybody at least something. And then, so you think about, the other thing that we always want to think about is group dynamics. And that, again, can be difficult in a time-limited situation. If you have more time, it's great to sort of get the jurors to bounce off one another so you can kind of see who's raising their hand, who's super talkative, who are the leaders in the group going to be. If you don't have a lot of time for that, a great idea is to also keep an eye on them at lunch. Look at them in the hall. Who's hanging out together? Who's kind of like making everybody laugh? Those are the people who are going to be more persuasive. So when it comes down to making those peremptory choices, you want to think about, who are my leaders? Sometimes you have someone who's just crazy, like a nut job, right? We've all seen that juror, and like, oh, this guy's driving me crazy, but he's not going to bring anybody with him. He's super polarizing. On the other hand, you have the person who's sweet, the person who's bringing cookies, the person who's gathering everybody up for lunch. That person's going to be much more persuasive in your jury. So you want to evaluate sort of group dynamics and leadership, and figure out, when you're making those tough choices, you get rid of the strong jurors, not the weak ones, right? Because particularly if it's a majority, if you don't need a unanimous verdict, you realize, all right, I don't like this person or that person, but look, they're not going to bring anybody with them, so it's probably somebody that I can live with. Jump in at any time, boys. Got anything?
Go ahead.
You're doing good.
All right, so how do we formulate our questions? So when you're asking a question, you want to ask a question that gives you information. So that's your primary goal when you walk into jury selection. You want to get information. If you're talking more than the jurors are talking, you're not doing it right. So the main thing that you want to do is get them talking and get the information. But our goal is to, when we're asking our questions, we want to find the bad jurors. We walk into jury selection, like I said at the very first slide, we're looking for the people we want to challenge, hopefully for cause, and if not, then to inform our strategy for peremptory challenges. We are not there to sell our case. We are not there to make friends. I mean, we're not rude, but we're not there to really kind of, the bonding part of it. That's not really what we're there for. We're there to find the people who are not going to be able to listen to our case. So when we formulate our questions, we do so with the goal in mind of finding the bad and hiding the good. Finding the bad and hiding the good. I don't want to ask a question that's going to reveal a juror that's amazing for me, because I'm going to think, I'm going to guess, and I'm going to hope that the other side's not as good as Voir Dire as we are. So I don't want to do the other side's job. So when I'm asking a question, the 90-10 rule is this. Think about, so if 50% answer one way, 50% answer the other way, that doesn't really tell you anything. That doesn't move the ball forward in terms of figuring out who you want to keep and who you want to get rid of. So you think about a question, 90-10 or 80-20 means about 10% or 20% of people answer one way, 80 to 90% answer another way, and the small percent are the ones who are bad for you. Okay, the small percent are the ones who are bad for you. Because if the small percent are the ones who are good, then you're identifying your good jurors. So let me give you the classic examples that we all used to ask: how many people think there's too many lawsuits, or how many people think that verdicts are too high, about right, or too low? Now, nowadays—
You got rid of too low.
Yeah, nowadays we don't, because if the too low, who raises their hand on too low? Like the best jurors, right? And it's so interesting because now, like, defense lawyers are asking to have those questions added onto the questionnaire, because they know most people say, oh, shit, even I would say, oh, there's too many lawsuits. It doesn't mean I'm a bad juror. It doesn't help us, but the people who don't think so or do think verdicts are too low, those are the best plaintiff jurors. So that's a 90-10 the wrong way. So we ask other questions. We ask about caps, because that is one that's more of an identifier. That's a more strong tort reform view that not very many people, except the ones who do and really believe in caps, they're obviously people who are bad for us.
What about our favorite question that we learned?
Our favorite question.
We learned from the defendant this question.
We did learn from the defendant. So our favorite question is, and I don't remember if I put it in here or not. If I didn't, I'll pop it up in hour 2. So our favorite question is, personal responsibility. It's a huge factor in all of our cases. That is, again, like sort of the backbone of the tort reform movement, is the idea of that people who sue are doing so because they don't want to take personal responsibility for what's happened to them. And I used to ask that as a strongly agree to strongly disagree. And it was most people who file lawsuits don't want to take personal responsibility. Do you strongly agree, somewhat disagree, strongly disagree? Problem with that, of course, is that it identifies the strongly disagree people, the people who are good for us. And so on one questionnaire, the defense had submitted it, and it was a dichotomy question where most lawsuits are brought by people who have had unfortunate events happen to them, A, and then B are brought by people who don't want to take personal responsibility. And what I have found in venue after venue is that is an 80-10, 80-20, 90-10 question in our favor. Most people say, yeah, most people who file lawsuits are because they've suffered an unfortunate event. But the 10% and the 20% who pick the second one are always the very worst jurors.
So we did a lot of focus groups with that, and we found that almost every juror that said that they don't take personal responsibility was a defense juror. We did it in an actual case, and we got lucky because we learned that question from the defendants.
Yeah, and I was like, that's our favorite question now.
It's now my favorite question. Sure.
Yeah.
I think it goes, do you believe most people that file lawsuits are the victim of an unfortunate incident, or most people that file lawsuits fail to accept responsibility,
or do so because of
their own
fail to
actions?
Take personality. Yeah, we'll pop it up. I'll pop it up at the break because we have it. So it's most people.
And the
fail
people
to
that go that is a great identifier for those bad jurors. And the one that I still believe. Do you believe jury verdicts are excessive, too high, about right? Excessive. Those people are generally not going to be good for you.
Yeah. So again, we take it, so that's an extreme response. Not very many people say excessive, and the ones who do are really bad. So yeah, sometimes we take out the too low, but sometimes defense is smart, and they're like, put that too low back in there. So I just like to ask the one question: who thinks verdicts are excessive? Right? That way you're only getting the people who have that view, as opposed to the ones who are going to maybe be okay for you. All right. So what else can you do when you have a limited amount of time? Use the judge. Right? The judge is not going to limit their own time, and so I always want to submit questions to the judge, particularly those questions that you don't really care about in terms for cause. Now, I'm not going to ask the judge to ask damages questions because they're just going to rehabilitate the jurors who have bad answers. I'm not going to have them ask any of my bias questions, but we're going to submit to them who's been in an auto accident, who's been in an accident with a motorcycle, who has, who knows somebody who's had a head injury, whatever those sort of background and information gathering questions that you want to know. You can even have them ask who's filed a lawsuit, who's been sued, who has been accused rightly or wrongly. This is a really good question. Who's been accused rightly or wrongly of causing someone injury in any type of accident? The rightly or wrongly gets the people who are like, yeah, I was in this car accident, and they came back a year and a half later and said that they had, that they were injured. And it really brings out sort of the bitter people who've had negative experiences with lawsuits if you do that, who's been accused rightly or wrongly of causing someone injury. It's better than just a plain who's been in a lawsuit or who's been in an auto accident. And anytime you're asking those questions about lawsuits and auto accidents, you want to ask whether or not they were satisfied with the process, satisfied with the outcome. Because again, you get jurors who've had experiences with the legal system that were negative and who are disgruntled and feel like they got cheated. They're incredibly skeptical of all other lawsuits.
They're bad jurors. Somebody that got sued, and it happened in that case, my partner on this, they say, oh, it was the other person's fault, and they sued us.
Yes.
Those people are bad.
That's right. So in this case, I forgot about her. There was this one where...
She was pretty good on everything else. She looked pretty good. And that question drew her out.
That's right, and because she was driving and her partner was driving and like a drunk person crossed the street and her partner hit the person and then they got sued for it. And she was good on everything else, and when that revealed, then she just went to town.
Kyle.
Did you say that the plaintiffs who felt they didn't get a just result also pay?
Sometimes they are.
But not always. They could actually be good. But for sure, if you got sued, period, it's not really.
That's right. So
unless they say it's like a little fender bender and the insurance company took care of it.
And if they say like,
some
hey, I feel
people
like it was
say
legit.
that.
If you got sued and you thought, yeah, I mean, it wasn't my fault, you know, it was fine, insurance took care of it. But the question about the plaintiff, you know, we talk a little bit about similarity liking versus similarity rejection. So somebody who is similar to your client could have a lot of empathy, sympathy could be great, but they also could go the other way and be like, look, I was hurt pretty bad and I got $100, so, you know, $100,000, so why am I gonna give your guy $10 million?
Same thing in wrongful death cases.
For sure.
Look for people that have relatives in the military or they're in the military, because there's a small, I think maybe 10,000 or some death benefit you get in the military, and they're very skeptical on wrongful death damages.
And the same for people who've lost a loved one and gotten nothing for it, right?
Oh, yes.
You know, those people they'll kill you. You think, oh, maybe they'll get what it's like.
I
to have
got
lost
killed
a
by
loved
one.
Yeah, they will kill you, right? So somebody who has lost a loved one, particularly a parent, at a young age, those are typically very problematic jurors in wrongful death. Yes.
Yeah, I got the same question along with, you know, people that have either open claims, because frankly, very few of them have gone to trial, right? So it's usually, I have an injury, I hire a lawyer, and I was not satisfied with the outcome. So it's someone that never saw the inside of the courtroom, but they're kind of holding against us as
Lawyers. Yes.
You know, you guys don't do a good job because
100%.
take all this money and then just kind of
That's what you're looking for. That's a problem.
Absolutely, absolutely. And, or that they couldn't find a lawyer to take their case. I've had that as well, where they're just disgruntled with the system because they think, oh, the lawyer wasn't gonna make enough money on my case and didn't take it. And so then, again, they will be disgruntled with the system. Yeah, that's a good point.
have these injuries that are real, they can sympathize with your claims. There's still people that are just too risky to keep.
You know, the riskiest juror is the one who's in the same situation as your plaintiff, and here's why. You know, there's a concept called defensive attribution, which is a psychological concept where we want to believe that bad things aren't going to happen to us. And when we see that bad things have happened to someone else, we blame the victim. We think of the reasons why it happened to them, and you think about why it wouldn't happen to you. So you say, I wouldn't have, you know, made that turn. I always look before. I never run off. I wouldn't have crossed the street. How do you?
I wouldn't have put my hand there.
Yeah, how do you let yourself get hit by a gigantic bus? You know, like there's these things and the closer in similarity you are to someone, the more likely it is to trigger that defensive attribution. The research on it started with rape victims and rape trials back in the 70s. A lot of social science were looking at that and found out, contrary to what your expectations were, women were often much harsher critics and much harsher judges of rape victims than men because of this perception of, okay, how would I avoid being in this situation?
Don't you think that women are tough on other women in the trial?
Yeah.
I mean, I find that they really hold them to a higher standard. But I think all jurors, no matter how much bad stuff they've done in their life, they expect the plaintiff to be pure.
Yeah, it's true. And so, but, you know, and I think that's, the other thing to think about is if you have a similar juror who's against you, they're going to be the strongest juror in that room because they're going to say, look, I had this experience and let me tell you, this is how I did it, or this is how I would have done it, and this person's not really that hurt. So you want people who have injuries, people who are in chronic pain can also be really bad for you, even though you think they might be good because they're like, I get up and go to work with pain every single day. But you know who is good is caretakers, people who know someone, who have a loved one who is in chronic pain. They're typically good, but the people who they themselves have chronic pain are often like bootstrapper, get over yourself, you know, get up.
Well, the same thing with emotional distress, catastrophic injury. If they know someone close to them, they're usually going to be good for you.
Yeah, but if it's they themselves,
them to forget it.
Yeah, exactly. All right, any other questions on that? Okay, so I was going back to asking the judge to ask the questions. Okay, just remember where we are. So you submit judicial voir dire. Sometimes if you submit a lot of judicial voir dire, so what we like to do is we always try and get a questionnaire if we can. Not always, but most of the time we try to get a questionnaire if we can. Sometimes I've had success when the judge says no questionnaire, then we put them all as judicial voir dire, and they're like, oh, okay, maybe just do the questionnaire because I don't want to ask all of these questions. But anyways, definitely utilize the judicial voir dire if you have the opportunity. But if you do have an opportunity to do a questionnaire, you're going to increase your chances of getting that questionnaire if you keep it really short. You know, we don't need a 20-page questionnaire. We're usually looking at 3 questions, really, in the whole thing, and we typically have only overnight to go through it. So keep it short, and if you can get the other side to agree on the questionnaire ahead of time, you're much more likely to have success in getting it granted by the judge. So I'm going to let Brian kind of talk about how he does his introduction. You're going to see him do his introduction when our mock jurors get here. But what do you want to do when you're starting jury selection? The most important thing is to set the tone, right? You want to set the tone in terms of, okay, what are we doing here? And you want to encourage people to talk. Public speaking sucks, right? Jurors are nervous. They don't want to say anything. They're reluctant to raise their hand. It's a big room. There's often a lot of people there. It's difficult. So you need to sort of break the ice. You need to be a human being. You need to warm up the crowd a little bit and kind of get them comfortable. I think it's really important to talk about what jury selection is and what it isn't. You know, because you're going to have to think about the judge or the defense who's going to say, oh, you follow the law and the judge's instructions. You can be fair, can't you? And so we say this isn't about fairness. It's not whether you're fair. I think it's you're all fair people because you know what? Everybody thinks they're fair. Everybody, no matter what comes out of their mouth, they're like, but I'm a fair person. So you have to say this isn't about whether you're a fair person.
Well, if you have some judge that's like that, and many are, where they say they can be fair, they follow the law. Once you get that, then you start incorporating that in yourself. You can follow the law. You can be fair. But on this one issue of emotional distress, loss of enjoyment of life, you have an issue, you're leaning against that. And therefore, you take it away from the defendant. It's called the prehabilitation. You take it away from the defendant before they do it. And once you see what the judge is doing on the cause, you incorporate that into your questions to take it away from the defense.
And it's important to do your research, do your homework, know what your statute is, know what the code is, know what your case law is. We come with the cause brief when we go to trial, which has a bunch of cases that we cite that says follow the law is not a remedy if they've already said bias. It's like an 1800s case, but we're like, old law is good law, right? So we always bring that, and we have, you know, there's different language in California where party starts at a disadvantage. So we know that that's a code or a case, so we use that language. Our code is a state of mind of entire impartiality. It says nothing about the law or about fair in our code. So we say, not able to be an entirely impartial juror in this case. And then you also want to destigmatize bias, right? You want to encourage people to bring up their biases, and you can bring up an example of your own bias. What you really want to do is say that bias is, you know, bias is a dirty word for a lot of people, and it's not. Bias is a leaning. Bias is a preference. Bias is, you know, favoring one thing over another. We all have them, and you come up with examples, and you explain your own personal bias, and then later on, you refer back to that. So for you, that's like that, you know, your cherry pie bias. So Brian will give an example of that probably when he gets up. So that's the idea. And then again, like I said, you want to pick at least one question that you ask every juror. For us, it's usually an open-ended question on non-economic damages. Close-ended questions, when you're short on time, you have to ask some close-ended questions. But if I want to ask one question of every juror, I want to ask them, what is your opinion about the idea or concept of awarding money for emotional distress, mental suffering, loss of enjoyment of life? Not, do you have any concerns with it? Nope. What do you think about it? What are your thoughts on it? And what's nice about this idea or concept, you get jurors who don't want to disclose, and they say, well, I haven't heard the evidence. I want to hear the evidence. I want to hear the evidence. Get it, yes, I understand you want to hear the evidence and we haven't presented anything yet. But aside from that, I just want to know what you think about the idea or the concept of giving someone money for these things. And then you can elaborate and say, I've heard people say, we all go through emotional distress and nobody's paying me any money, so why should this person get any? Who shares that view, even a little bit? So I like to do open-ended that one non-economic damages question with every juror. And don't say non-economic. They don't know what that is. They don't know what plaintiff is either. So I always say, you know, the person who brought the lawsuit or the person's name, and don't say non-economic. Say what those elements in your jurisdiction are and use those words, not non-economic damages, because people don't really understand that. I think the other thing that you need to remember with non-economic damages is you have to constantly clarify what it is and what it isn't, right? Like,
We have to say, look, medical bills, everybody can give medical bills. Loss of income, but it's the other area that we want to talk about.
right, and
Upset, and try to like make it, well, you know, you tell them there's no tests, it's purely subjective.
there's no formula.
No formula. Some people get on that, the formula.
Yeah.
Well, I don't know if I could do that.
They still get confused a lot, and they'll they'll say, well, but for therapy for emotional distress, you know, that seems appropriate.
That's
You still
economic.
have to still describe it.
That's right. You have to say, I'm not talking about therapy. I'm not talking about funeral costs. I'm not talking about
prescription meds.
Yeah, I'm not talking about medications. Yeah, so what is it and what it isn't? And what we like to say is we're talking about money for the experience of having a brain injury, money for the experience of living in chronic pain, money for the experience of having been terminated wrongfully from your job, right? So that's how we do it. We do it as sort of money for the experience to kind of take it out of that realm. Another thing that we like to do, if we're allowed to, for both non-economic damages and for wrongful death damages, is to put the list of the elements up, put it on an Elmo or put it on hand it out on a piece of paper. It really brings home the concept of what you're talking about, and it's super interesting. Even yesterday, when we did our mock voir dire, there was jurors who were like, okay, yes, pain, yes, this, but I'm not giving you money for anxiety, no way. Right? Or there'll be certain elements on the wrongful death guidance. I'm not giving money for guidance. I'm fine with this and this, but not that one. So you can actually get jurors who will say, yeah, that right there, I'm not going to do that, no matter what you present. And so you say, okay, no matter what you hear from me, you're not going to give any money for this particular element. And sometimes you can get a cause challenge from that. I will say one other thing about non-economic. Oh yeah, go ahead. If they're low.
If they're low.
If they're
Me
low.
personally, I don't really waive anything. I
don't
like
waive
try to get every dime.
Yeah.
I don't go by that, oh, it's only 5,000 in medical bills and the wrongful death. I don't care.
I wouldn't in a
try to
wrongful
get it
death.
all.
I might in if it's 5,000, and I think sometimes we do it if maybe we have like sort of a questionably employed person.
Yeah, if it's subject to a lot of scrutiny and you don't really have good records and your loss of income claim is going to be blown up, then, you know, obviously you don't want to do that because you want to maintain your credibility.
Yeah.
But
And then,
generally, I don't believe that the jurors line up the non-economic or the pain and suffering, emotional stress with the medicals or the economic. I don't think they really look at it for a ratio.
I think the concern is that it anchors it low. And you know, there's some evidence to suggest maybe it does. But I think you just have, it's kind of a case-by-case situation, I think. But I think that I'm surprised by sometimes clients like their medicals are like 300,000 and they want to waive those. I'm like, why would you waive that? Like that's a substantial
You know,
amount of money.
sometimes what I've done is stipulation on the meds, and then you just get them to stipulate. You don't say anything, and then when you get to getting the jury verdict form, and they have the boxes, rather than sometimes they just want to put it in. We're not fine. So, Judge, that's not an issue for the jury to decide. They're only deciding issues of fact. That's been decided. That's not part of this. And I've been successful every time in that way.
That's so great.
They add it back onto the verdict and the jury never hears. So
Yeah.
that's something you can do. And it makes sense. Otherwise you say, I'm calling in every doctor, I'm proving up every bill, and then finally, all right, we stip. And then at the end you hit them with, okay, jury doesn't get to know.
Yes. Smart.
Okay, where are we at?
What else was I? So I was going to say one other thing about non-economic, but I don't remember what.
Well, you'll remember.
I'll remember. It'll come to me. All right. So this is the setting the tone, getting them willing to talk. And then the other thing that you want to do is, sometimes you ask a question and it's crickets, right? Nobody says anything, and you're just like, shoot. Do not just say, okay, I see no hands, and move on. Pick somebody, just pick someone. And you want to pick someone who you think is going to be bad, right? We always want to try and start with a juror who's going to be bad and who's going to say a lot. Counter to what some lawyers are like, I don't want to taint the panel. You're not going to taint the panel, right? Nobody's going to change their mind because of something that a stranger says in the room, unless they were already predisposed to think that way anyway. So sometimes you can tell just from judicial questioning, like, oh, this guy's going to be no good. And you just pick someone. You got to start somewhere. So pick.